Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Govan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. 2nd, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. 3rd, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makitas. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makitas parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, well, actually, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride, and his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Nikita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Nikita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of the felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you've made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I think, well actually I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Mr. Evans.